In the practice of real estate agents have a very significant responsibility to ensure they're providing informed and accurate information. Because y'all, obviously, the principals involved, buyers and sellers both, y'all, there's a lot of money at stake on both sides, and they're making some pretty big decisions here. In fact, this is usually the most expensive investment that most people will ever make when it comes to buying and selling real estate. And real estate agents have an obligation, because of their fiduciary obligations, to provide accurate information. And one thing you want to be very careful of here when you're practicing real estate, if you don't know what you're talking about or you're not sure, hush. Just be quiet, okay? Because anything you say, your client has a right to assume it's accurate, and they're going to be making business decisions based on the information you provide. And if it turns out not to be accurate, you could have some issues here. There's no doubt about it. So what we want to talk about right now is the difference between misrepresentation and fraud. Look, at the end of the day, I think, in terms of, if I were to ask you, how common is it that real estate agents ever find themselves in a courtroom, because they're getting sued for one reason or another? And, I would say it's probably a pretty small percentage. When you look at the sheer number of licensees out there versus the number of those that ever get sued, I would think and certainly hope it'd be a very small percentage. But, at the end of the day, you don't want to be in that small percentage, right? And so anyway, I wanted to say that because what we're about to go over right now, I'm not trying to scare anybody. However, you got to be cautious about just throwing stuff out there, providing information, and you don't know if it's accurate or not. Be careful with stuff like this, because if an agent gets sued, the question is, would they be liable for misrepresentation, or would they be liable for fraud? Assuming they did provide information that we now know for whatever reason was not accurate and has created and caused damage to their client. Well, what's the difference? And I will tell you that there's basically a one-word difference between misrepresentation and fraud. And that's intent. What was your intent when you provided the false information? Obviously, if you were to be found guilty of either one of them, neither one's going to be a happy day for you, okay? But I can assure you, if you had to choose between the two, I think I would rather be liable for misrepresentation than fraud. And the main reason is, fraud is illegal. So now you got other issues. Misrepresentation is not illegal. Again, misrepresentation is when you provided information you believed was accurate. It's just you found out later it was not. So there was no ill intent when you provided the information. So that's just considered misrepresentation. But still, at the end of the day, if you misrepresent something intentionally or not, you're going to have to be responsible for that. You could be liable for that. But fraud is a whole nother ball game. So if someone's going to be suing you, and I can assure if we go to court, they're going to be suing you for fraud. They're going to try their best to prove fraud. They may have to settle for misrepresentation, but they're not going to start there. They're going to start with fraud. And, there are basically 6 elements of fraud, okay? And anybody suing you for fraud would have to be able to prove all 6 of these elements. If they can prove all 6 of them, you're going to be liable for fraud. So let's look at what these elements of fraud would be. Number 1, you made a false representation. You said something or provided some information we now know is not accurate. That's the first step. Number 2, whatever you misrepresented was material to the transaction. Now, what does that mean? Or in other words, it has to be a material fact. Well, what causes or constitutes a material fact? If they can show that the information you provided, they relied on that information in their decision-making process, then that was material information because they relied on it. So that's number 2. Number 3, and to me, this is the biggie right here. Of all 6, this is the biggie. In fact, they break this one out kind of into 2 parts. The first part says when it's made with knowledge of its falsity. Now, if they can prove that you knew it was not accurate when you said it or provided it, then you pretty much deserve whatever you get. But here's where you better be careful, where it says, or reckless disregard as to whether it was true or false. That's where it gets a little sticky right here. Or reckless disregard as to whether it was true or false. Well, what does that mean? An example might be, in order to prove reckless disregard, they might, if they could show that the information you provided, you obtained it or found that information from some other source, but you did not verify that information yourself. You just assumed it was accurate. Like off a website or YouTube or whatever. You have an obligation as a fiduciary or someone acting in a fiduciary capacity. You've got an obligation to verify information. You can't just throw stuff out there and hope it's right. But if they can show that the information you provided, you obtained or grabbed from some other source and you did not verify it to ensure it was accurate, that's just reckless disregard. Well, I saw on YouTube it said such and such. I'd go with that. Okay, that's just reckless disregard. You don't know if that's accurate or not, right? So, that's the biggie in my mind. Just be careful with this. The fourth element of fraud is when it's made with the intent for the recipient to act or refrain from acting. So in other words, when you provided the information, you intended for them to use the information in their decision-making process. Number 5, if they actually did, in fact, rely on that information. And then number 6, they suffered damages as a result of that information. So again, if they can prove all 6 of these elements, this is going to be a bad day. You're going to be liable for fraud. So not only are you looking at potential significant damages to whoever you've harmed, you broke the law. So you could have a lot more issues for being liable for fraud. But here's the other kicker. They only have to prove just any one of those 6, just one of them, and you're going to be liable for misrepresentation. So if they can show or prove any one, that's misrepresentation. If they can prove all 6, it's fraud. So it's imperative. I'd say the main thing I would take out of this section right here is verifying information. You cannot just throw information out there just because it sounds good or you heard it from somebody else and they're not the subject matter expert. In fact, rarely would I ever want to be the source of information that's not certainly within my lane. Um, just be careful about this stuff. You have to verify information. You have that obligation as the fiduciary. Okay. Okay, so we already talked about the misrepresentation. We know the difference between misrepresentation and fraud. But then you see this E&O insurance, errors and omissions insurance. And it's kind of what it sounds like. It's insurance to cover damages in case of an error, a mistake. Is it possible as a real estate agent, you could make a mistake? You could suggest or advise your clients to do such and such. They do it, and it turns out not to be the right thing to do, causes damages. That's what you might have E&O, or errors and omissions insurance for. That will cover innocent mistakes, unintentional mistakes. Now again, if they were able to show or prove fraud, the insurance is not going to cover you. There is no insurance to cover you for breaking the law. But if you make an innocent mistake, right, an unintentional mistake, those things happen. We're all human. Hopefully when you make a mistake, it won't rise to this level. But you're going to make mistakes. It's just part of the business, part of life. But where it does create or cause damages, that's when you better hope you've got E&O insurance. Now, do you have to have errors and omissions insurance to practice real estate? No. By law, the Supreme Court has ruled, no one can be forced to purchase insurance, of any kind, but here we're talking about errors and omissions insurance. So you can't be forced to buy it. Now, having said that, could the company you decide to hang your license with, could they require you to have it? They could. But wait a minute, Frank, didn't you just say they can't make you have insurance? And that's true as well. But could the company say, well, if you choose not to have E&O insurance, you're not going to be licensed here? They can do that. Again, so they can't make you get it, but they can decide you're not going to practice under this brokerage if you don't have it. So, I would tell you, I think you need it. Whether the company you're licensed with requires it or not, I can't think of anything much more irresponsible than acting in a fiduciary capacity and you don't have insurance coverage to cover damages that you potentially could create, hopefully by mistake or an error, but you need E&O insurance, okay? So you can look into how much that is and stuff like that a little bit later, but that's what errors and omissions insurance is for. But then you see this term called puffing. Well, what is puffing? Puffing is stating an opinion that others may consider to be somewhat of an exaggeration of reality. If I say, if somebody asks me, Frankie, do you think this is a good neighborhood? I might say, well, in my opinion, this is the best neighborhood in the whole state. Okay, well, and I may actually believe that. But others might think, all right, well, you're exaggerating a little bit. How can you know if that's the best neighborhood in the entire state? Well, again, that's my opinion. And as long as I believe that opinion, whether some may consider an exaggeration or not, that's considered puffing. Now, is puffing legal? It is legal. There's nothing illegal about puffing or exaggerating. But I'm just going to tell you, you better be careful here. You're certainly threading a thin line, for sure. Quite frankly, I don't know that I would throw my I guess depending on what it is you're talking about. But I'd be careful about throwing your opinion out there too much, especially if it's could be considered exaggeration. But now I will say this, and you don't see it right here, but I'll just throw it out there. When you get your license and you decide to join the National Association of Realtors, they have a code of ethics that realtors must comply with, in addition to license law. And in their code of ethics, exaggeration is a violation. So you cannot, so if you become a realtor, you cannot exaggerate or puff. It would be considered a violation of the code of ethics. I don't think that you got to worry about that for state exam purposes. They're not going to be testing you on the realtor's code of ethics. They're going to be testing you on things we've already been over, license law, stuff like that. They're not going to be testing you on the code of ethics. But I'm just letting you know it is a violation of the code of ethics to be puffing. But is it legal? Yes. But you better be careful about how much you're puffing. Okay. You could certainly get yourself and your client into some trouble here if you're not careful.